saw that.
Please be seated and come to order.
All right, are we ready for the jury then?
Yes, ma'am.
Yes. Hold on, Deputy Johnson. Either the microphone or, yeah, good. Well, you can, but there's no jury here.
I guess when you went off the bench,
Okay.
was it, I've heard that you were going to have their last witness?
Their last witness, and we'll see where we are at that point.
Oh, okay.
Yeah, I don't know. If it's only going to take a half hour, I assume you have a motion,
Yeah.
so we would do that outside I can let the jury go home early, we could do your motion.
Okay.
And then start tomorrow with your case. Does that sound
sounds
okay?
good. That sounds good. I just
Good.
wanted to make sure, because I think there were people here
Okay.
that I had ready in the event.
Yeah,
but
I understand, but I think if it's
we
going
let them go.
to, if it's going to take till 4:15, I mean, I might
Yeah.
as well just excuse them.
Yeah,
at
no,
that
that's
point.
fine. I just want to be certain.
Okay, sure, no, I appreciate it. All right, thank you. All right, now,
Can you look while we're sitting?
all right, your next witness,
Your Honor, we would call Gary Benson.
Gary Benson.
Stand here, please, Madam Clerk, raise your right hand.
Swear or affirm to testify truthfully in this case under penalty of law.
I do.
Good afternoon, sir. Could you please state your full name and spell it for the court record?
Yes, it's Gary Benson. It's Garybenson.
Mr. Benson, are you the father of Christine Banfield?
Yes, I am.
Who was Christine Banfield married to?
Brendan.
Do you recall when they were married?
Yes, they were married in June 12th of 2010.
Okay. Did they have a daughter?
Yes, her name is Valerie Ava.
All right. And when was Valerie born? Do you recall that day?
March 30th, 2018.
Thank you. Were you present for her birth?
Absolutely.
All right. Where did that occur?
It happened at the hospital in New York, Good Samaritan Hospital.
All right. Remembering Christine's childhood, did you observe any medical symptoms that gave you concern?
Yes, several bruising, bloody noses.
Were they more than the average child's
Yes,
experience?
yeah, it was a concern to a pediatrician as well.
Judge, I'm sorry, I'm going to object about medical testimony.
Objecting to medical testimony.
Your Honor, at this point in time, he hasn't testified to medical
Okay,
information.
I'll overrule the objection at this point. Yes.
Thank you. Tell me about the nosebleeds. What
They
did you
were,
observe?
they were frequent and very hard to stop. So the doctor was, why we brought it to the doctor to go over that reasoning.
All right. Did you have to do anything to help her with these nosebleeds and bruising?
Well, yeah, we would do normal, put ice packs on the back of her head, keep her elevated so that, until it stopped, which was prolonged. Took quite a long time for them to stop.
And after these experiences, did you seek help of a medical professional?
Yes, we took her back to the pediatrician who suggested that she be tested by
Without telling us what the pediatrician told you,
Oh, you just asked me what I did. I'm
I
sorry.
understand. So let me ask you
Okay.
that question. What did you do?
We took her to the doctor.
Okay. Did you take her to just one doctor?
No,
Okay. How many doctors did you take her to?
my recollection too.
All right. And after taking her to these doctors, did you form an understanding of why Christine bruised easily and her nosebleeds were difficult to stop?
Yes,
Okay.
Judge, I'm going to object. That's informed by the medical professor.
All right.
We should have here if we're going to.
Okay, I'll sustain the objection unless you have a different.
Yeah, Judge, if the
foundation.
objection is hearsay, there's an exception. If the objection is foundation, we can go farther into how he formed his understanding.
What's your exception to hearsay?
Sure, Judge.
If you want to approach.
So, Judge.
You can approach, please.
As a result of Christine's easy bruising and nosebleeds, did she need to take any precautions?
Did she take any precautions? Well, as a parent, we took precautions to safeguard. When she rode a bike, she had to wear a helmet, knee pads, hand pads. Same thing with rollerblading. She was one that, when she was little, she liked to do all that stuff, but we restricted her from doing that because of all the injuries that she was getting like that. So, that continued for quite some time, keeping a close eye on her.
Did you provide her with any medication to take?
She didn't take anything on a regular basis. There was no medication for it at the time to take on like a maintenance drug or anything like that.
I'm sorry, there was not a maintenance drug?
There was no maintenance drug for what was the cause of everything.
When she was little, is that correct?
Yes,
Okay. Was there a treatment drug?
there was a treatment for the blood disorder, yes.
And did she receive that drug from you?
Not from me, only it was administered by a doctor.
Okay. To your knowledge, did she continue to have these issues as an adult?
Yes,
And what, if any, precautions did she have to take as an adult?
well, she always had to be cautious and not take any contact sports, anything that would prolong any kind of injury, internal or excessive bleeding would cause a problem.
When she was pregnant and due to give birth to Valerie, were you present with her?
Yes.
When decisions were made
Judge,
about?
I'm sorry, I'm going to object as to the medical care aspect of this, because I think we're getting into medical care.
I don't know if we are or not. I'll overrule it at this point.
When she was preparing for her delivery,
Yes,
were there any precautions that she took for that event?
yes, she had to take medication.
And again, you were present during the delivery, is that correct?
I was in the hospital at the time, yes.
All right. Judge, I don't believe I have any other questions. Thank
Okay.
you.
Cross-examination?
One moment.
Sure, yes, sir.
Good afternoon, Mr. Benson. Christine, as an adult.
Can you speak up a little bit more? I can't hear you.
Thank you. Christine, as an adult, would play kickball and volleyball, correct?
To my knowledge, she did play sports.
Okay.
Non-contact sports, yeah.
Did she take any precautions like wearing helmets or anything like that, like when she was younger? In those
When she
sports?
was younger, she did. I don't know what she did as an adult when she didn't live with us.
Okay, so you weren't certain of her as an adult. How long had it been since she'd lived with you?
When she graduated college, she moved out on her own.
Okay. And so probably 15 years?
Thereabouts.
Okay. And during that time, were you aware of her like competing in obstacle course type things called a mud run?
No, I'm not familiar with
Did you
it.
ever hear about it?
I'm not familiar with it, no.
Okay. It's kind of like a obstacle course where you're jumping over fences and.
Judge, counsel's testifying objection.
All right, I'll sustain the objection. Next question?
So you haven't heard about her doing any of those sorts of things, correct?
I'm not aware of it.
Okay. Aaron, one moment.
Sure. All right, no further questions, redirect?
Just one redirect. Mr. Benson, you were able to testify that precautions were taken at the time of Valerie's birth. Was Mr. Banfield present at Valerie's birth?
Yes, he was in the room with her.
How is that redirect?
How is that redirect? All right, I'll
on.
sustain the objection.
Thank
Any other
you.
questions?
No, thank you.
All right, Mr. Benson, you can have a seat in the courtroom. Thank you, Mr. Benson. All right, next witness for the Commonwealth.
Judge, Commonwealth would rest at this time.
All right, the Commonwealth rests.
Without asking Ms. Chrysler if I can take that back for just a second.
Okay, yeah, I'm sorry, yes.
Sorry.
Judge Commonwealth, rest.
All right, the Commonwealth rests. Ladies and gentlemen, I have a few housekeeping matters I have to take care of with the attorneys at this point, and that, based on the water issue, I'm going to go ahead and let you guys go ahead and go home a little early today, okay? So please do not look at any of the media, do not discuss the case with anybody, don't do any outside research, and we'll see you early in the morning, okay? We'll continue on with the defendant's case, okay? Thank you. All right, yes, sir, your motion?
Yes, thank you. Your Honor, this comes on our motion to strike. You currently have before you a 5-count indictment that was returned on September 16th, 2024. The makeup of the indictment was designed to cover a whole series of circumstances. The 5th count was use of a firearm in the commission of a felony. In addition, there were 2 additional indictments relating to child abuse and child neglect that were then sought through direct indictment again in December. I'm moving to strike all of those charges. What we have up to this point in terms of evidence, Judge, we haven't heard a single word from a single detective that was involved in the homicide division. We haven't heard any sort of credible evidence relating to what was espoused as a theory of catfishing for years now and had been working toward that. In fact, you have the only person that has even suggested anything, and this is probably the 3rd or 4th time that story has changed, is Juliana Perez Magalhaes. She's now testifying to what appears to be intended to fit right into whatever the Commonwealth's theory was regarding that, but doesn't even make it that far. She can't answer any questions with any sort of detail. In fact, without the absolute direct and oftentimes leading questions related to the Commonwealth, she wasn't able to answer a single thing. We went through in painstaking detail the numerous messages that at one point she might have said something about, but now she doesn't remember. In fact, I'm not sure her testimony is worthy of consideration, because she got to the point when I would ask questions, she would say, if you keep asking questions like that, I'm just going to tell you I don't know. And that happened numerous times, despite the fact that we patiently went through the evidence that we needed to go through in order to test and challenge her story. That story doesn't amount to, even in the light most favorable to the Commonwealth, something that's sufficient in order for these charges to go ahead. The charges themselves are an interesting, and I'll paraphrase essentially what needs to be shown, is that my client killed Joe Ryan after killing Christine Banfield. And the alternative, my client killed Christine Banfield after killing Joe Ryan. Then the next set of charges, which at least scream out that they're just a catch-all, is that my client killed Joe Ryan and within 3 years killed Christine Banfield. My client killed Christine Banfield and within 3 years killed Joe Ryan. We don't have any sense of what happened on that day, even in the light most favorable to the Commonwealth. There's no indication of who was killed and then who else was killed. There's no evidence to support that even in the light most favorable to the Commonwealth, under that statutory or that indictment scheme that was presented by the Commonwealth's office. As to catfishing, there's no indication, and there's certainly no evidence that would be credible toward that. And the Commonwealth committed during my motion for bill of particulars in September that was the theory that they were going on. Obviously, that doesn't appear to be the case because there's just not sufficient evidence. So we move on then to the evidence of Ms. Graff and the testimony. She tried desperately to paint a picture. Crime scene reconstruction, though it may be available all around the world, is not available in Virginia. And one of the reasons why this testimony has probably not met where the Commonwealth needs it to meet is that there's no indication as to timing. And those 4 indictments are all about timing. And so this isn't something that, hey, if they get close with their evidence, this is about in the light most favorable of the Commonwealth, they have to have a prima facie evidence as to each individual indictment. And the way it currently sits now with no timing evidence, with no actual confirmational evidence, first regarding that whether or not Christine Banfield, which is the threshold that they have to have shown at this point, is that she somehow abandoned her devices and this scheme came into place, which we've heard about for a year from various motions and various pleadings. And so this is the time when you're in a situation where you have not heard from a single homicide detective, though there were at least 12 in place at the time. You haven't heard a single thing from any of the command staff about this investigation. You haven't heard anything from the people that were doing this investigation except for Detective Leach. And Detective Leach has a specific purpose in this, and this is to introduce the items of evidence that he took photos of and the items of evidence that he sent away to the lab. There's nothing in any of the lab analysis that's been said that would implicate my client. And in fact, in listening to all of the evidence, it appears the testimony, the identification of any blood, if it was even done, would show that Joe Ryan and Christine Banfield are the contributors. This judge is not surprising given the horrific situation that was there, but it was a situation not of my client's making and was not something that he did. And so, Your Honor, I don't believe there's sufficient evidence, even in the light most favorable of the Commonwealth. And I believe that there's an obligation when you have someone who has changed their story so many times on the part of the prosecuting authority to take that into consideration. But let alone those issues, which will be taken up, I guess, at a later time, we have these indictments, and those indictments are the indictments that they chose to seek. They're the indictments that they had to work toward in order to be able to present the prima facie case, or in the light most favorable to the Commonwealth. Your Honor, I'd respectfully suggest that they've missed their target. There's not sufficient evidence, and I'd ask that you strike the five count indictment and even less evidence regarding what was indicted later on, which are the child-related charges. And thank you.
All right, thank you. Yes, ma'am?
If there is anything specifically the court would ask the Commonwealth to address. If not, I would simply point to the court that in the light most favorable to the Commonwealth, the evidence has been presented that Mr. Banfield shot and killed Joseph Ryan, that he stabbed his wife Christine, that all of that was done while his 4-year-old child was left in the basement, unattended, in a home where weapons were not only present but were in use, that the event in the light most favorable to the Commonwealth was in fact staged by the defendant in conjunction with the assistance of his nanny, and that at this point, I believe the evidence is sufficient to meet the standard before the court.
All right, thank you. Anything further, your motion, Mr. Carroll?
No, Your Honor.
Okay. And the factors of this case, just for the record, there's 2 different numbered indictments. The indictment 2024-666 are the indictments with the 4 counts of aggravated murder and a use of a firearm. As far as the 4 counts of aggravated murder, 2 of the counts are under Virginia Code 18.231 subsection 7, and 2 of the counts are under 18.231 subsection 8. As to the evidence in this case, in the light most favorable to the Commonwealth, I do find that there is evidence that can be considered by the jury for each of the elements of aggravated murder as they are outlined in the indictments count 1, count 2, count 3, and count 4 of 2024-666. That's based on the co-defendant's testimony, crime scene testimony, blood evidence testimony, and DNA evidence testimony at this time for those 4 counts. And as shown in Virginia, the Commonwealth can indict a defendant under subsection 7 and subsection 8 for the same murders when each of them constitute murders occurred as part of the same act or transaction, or in a 3-year period. So they don't have to choose at this point during the guilt or not guilty phase as to those 4 indictments. As to count 5, the firearm, there is evidence to go forward that the defendant did use a firearm in the commission of these acts. As far as indictments under 2024-873, count 1, child endangerment, and count 2, child abuse. In these matters in Virginia, it has been found that you can put children in situations that would constitute child endangerment and child abuse. In this case, we have evidence from the co-defendant's testimony that the child was brought into the house, brought into a crime scene. And the light most favorable to the Commonwealth would be that she was there during the occurrence of the events that had happened to her mother and to Joseph Ryan. And therefore, there is evidence for child endangerment and child abuse. And it's clear in the Virginia law that you can go under both the child endangerment and child abuse, and it's not double jeopardy because each statute requires proof of additional facts not found in the other. So that's 2 distinctive offenses. So based on that, and as far as the co-defendant's testimony, I cannot find as a matter of law that her testimony was incredible. The weight of the evidence is up to the fact finder, so I'll deny your motions at this time, okay? So we'll go forward tomorrow. Has anybody been discussing jury instructions with each other, or?
I don't think with each other, Judge, we have ours prepared, and we can certainly exchange.
All right, if we could exchange those at some point in the next 24 hours and maybe talk about them. And if we'll see where tomorrow goes. You have at least 3 witnesses, correct?
I have,
Could you just use the microphone? I'm sorry, I had trouble sometimes hearing you.
I'll have a couple witnesses available beyond 3, so maybe 4 or 5.
4 or 5
I
for
also
tomorrow.
have evidence to introduce, Judge.
Okay.
And so and this is good that we're talking about this, is I wanted to, at some point, when it's appropriate, to introduce the first 70 exhibits.
Okay, and you have them in electronic
I've
format,
given it
just
to- I've
one
given it to
file
you.
each? Okay,
Yeah.
perfect. Okay,
And so, but I also will want, because they didn't see it as we were going through it, I want to be able to introduce them have a reasonable period for which they can read their sheets, you know.
Well, if there's not objections, I assume.
Yeah, well, I guess as we go through objection,
We're
but that's
gonna
what
have to
my
go through
thought is.
objections.
It's, you know.
Well, if there's not objections, I assume.
Yeah, well, I guess as we go through objection, but
We're
that's
gonna
what
have to
my
go through
thought is,
objections.
which could take up some time.
So would you rather do that first before your first witness?
I'm thinking that.
Well, is there any objection first to him doing that before his first witness, going through all his evidence?
No. No.
And then we'll just go one at a time, and if you have objections, we can cover them at that point. Is that okay?
Yes.
I mean, if you can get with it, if you agree upon some that are not objectionable, that's fine.
Yeah, if counsel could provide them to us.
Yeah, could
that
you
would be helpful.
provide, I think I have, and let's just make sure for the record, for defense, I have, let's see, I have 1 through, oh, gosh, 1 through 71, and that's all the letters and jail mail, 1 through 71. So if you can get those to the Commonwealth, and then I have 80, 80A, 80B, 80C, 80D, as in Delta, and then 81. That's what I have for the defense. So if you can get those to the Commonwealth tonight, so they can review them, and then they can tell me tomorrow morning which ones they have objections to as we go through them, that would make it faster anyway.
Okay, thank you.
Okay, can we do that?
Yes.
All right, and you can, and so you'll go through tomorrow and possibly the next day as well, correct? With your
Yes.
evidence?
Yeah, I do believe so. And
Okay.
possibly into the next week.
And into next week, okay. I just want to make sure I get it straight, but yeah, if you could start working on jury instructions, though, I'd appreciate that. Yes, ma'am.
Just a question for Mr. Carroll, if he knows the time that we might receive those files.
As soon as I go back.
Okay,
As soon as we go back.
thank you.
All right, any other questions?
Judge, the only, thinking through the exchange
Yes.
of jury instructions.
Okay.
Certain instructions will be relevant based on what Mr. Carroll
I
presents.
understand, and if you, I
And to
mean, we
this
might have
point-
to add to the stack at some point, but if you
Okay.
could maybe just get the bulk of the ones we know are going to be.
Yeah,
part
we
of the
certainly
case.
have the charging instructions
Okay.
and all of the standard Commonwealth
Are they going to be
instructions.
waterfall? I mean, it's.
Yeah, I believe so,
Okay,
Judge.
so, yeah, so you got to get all those so we can
Yep.
get that taken care of. And maybe start thinking about a verdict form too, because it's going to be rather lengthy.
Yes, ma'am.
Okay. All right, anything you have, Mr. Carroll?
No.
All right, we'll see you tomorrow morning at 10 a.m. then. Thank you.
Thank you.
Thank you.
All right.